Question number 2.
Exponent calculator.
Uh, may I just
Yes, just give us a minute, please. Second appeal. No, don't think so. After we know it. Yes.
but I'm the defendant, appellant before your lordship, my lord, in a suit for eviction. Now, my lord, the suit was filed on different ground, various ground, right? Reasonable requirement, default, other grounds. Ultimately, suit has been, my lord, decreed on the ground of subletting. Appeal prepared. Now, my lord, appeal dismissed. Now, this is the second appeal. Now, my lord, before filing of the present suit, but the plaintiffs the plaintiffs in the court below and the respondent before your lordship has filed a suit earlier. Now, my lord, I just request your lordship, my lord, I've handed over the copy, although it's a long time back. But if your lordship see once the copy of the earlier plaint,
83.
The earlier plaint is, my lord, 83.
Where is that? You have given us a copy.
But the copy has been given earlier occasion, your lordship considered, my lord. May I just find out for your lordship, my lord?
Yes. Got it. Yes.
Now, my lord, kindly see who are the plaintiffs. But Devi Prasad Mal, Homor, in the first page, your lordship will find. Devi Prasad Mal, Shomor Mal, but they are the plaintiff. Who is the defendant? Ananto Engineering. Kindly mark my lord, Joyanto alias Hora Das is the defendant number 2. I just find out for your lordship, my lord. Oh, find out.
Yes, please mark it where it is.
But this is the plaint of the certificate of the plaint of the earlier suit.
Yes. Devi Prasad Mal. Yes.
Devi Prasad Mal, Shomor Mal are the plaintiffs. Ananto Engineering is the defendant number 1 and Joyanto alias Hora Das is the defendant number 2. Now, my lord, what is the suit for? Your lordship will find at page 4, suit for declaration and injunction. Now, my lord, I will request your lordship kindly straightway come to my lord, paragraph page 9.
Yes.
Now, page 9, they have specifically mentioned, my lord, if your lordship see page 9, 5 line from bottom, the word starts with and also restraining the defendant number 1 to sublet the defendant number 2 over the property. Jesse Bhattacharya has already seen, my lord. Page 9, my lord, 5 line from bottom and also restraining the defendant number 1 to sublet the defendant number 2 over the property in question and also by delivering possession over the same by a means in required to be passed, otherwise the plaintiff will suffer. Therefore, the subletting ground, my lord, they have already taken in the earlier suit, and in that score, my lord, now, my lord, the prayer has been made at page 10. A decree for declaration that the plaintiffs are the absolute owner of the property mentioned in describing the schedule herein below, and the defendant number 1 is the tenant under the plaintiff, with a further declaration that the defendants have no manner right to change the nature and character of the property. Now kindly see next, the defendant number 1 have no right to sublet the defendant number 2 over the property mentioned. Therefore, the subletting they have already mentioned in the earlier suit. Now, be that as it may, but they did not pray.
Yes.
They did not pray any recovery of position in the earlier suit. Now, my lord, I am requesting a lordship, if your lordship consider, my lord, section 34 of the Specific Relief Act. The Act provides that if a person is entitled to claim any relief and if he has not claimed the relief in earlier suit, he is debarred to claim the relief in the second suit.
Not in the earlier. It's in the earlier suit. It is doing from public. There's nothing public. Was there any subsequent development during the pendency of the suit?
No. Already my case is that this particular person is one of my partner and whom he claims to be the subtenant, and from the beginning, from the running of the business, this defendant number 2 was there. Knowing fully well, he filed the earlier suit, and in earlier suit, that subtenant, according to him, that subtenant entered appearance as defendant number 2, filed written statement and made his categorical statement that I am here from the beginning. Now, in view of those statements also, he chose, my lord, not to pray for recovery of position. Now, my lord, in that suit earlier, but I have handed over the judgment. That suit was rightly, wrongly has been dismissed. He chose not to prefer any appeal or move before the higher forum. The copy of the judgment of earlier suit, my lord, I have already handed over before your lordship. Now, once if your lordship considers section 34 of the specific relief.
Huh? What I am saying. There was no subletting at that time.
Yes, my lord.
It was a prayer for restraining them to sublet.
May I, if I show to your lordship, my lord, if I show to your lordship,
Yes.
but the written statement filed by the that particular defendant number 2.
Yes.
But I have handed over the written statement earlier occasion.
Defendant number 1 is Jayanta Das.
Defendant number 2 is Jayantu Das, who claims to be the subtenant.
He has filed an amended WS.
Yes, I am showing to your lordship. And if your lordship wants, my lord, see, but paragraph 6 of the plaint, according to your lordship, my lord, that my lord, there is no story of my lord that he is trying to create subtenancy.
Because you pray for order restraining them from subletting. You don't say it has been sublet.
My kindly see, if your lordship conjointly read paragraph 6, if I
Of
plaint. The defend, may I read? The defendant number 1 is so dangerous and notorious type of person in the locality, and their sole intention is to grab the property involved in the suit, and also trying to sublet the same by delivering of possession. And next one, may I just read my trying to sublet the same by delivering the possession over the property mentioned and described in schedule herein below to the stranger, that is defendant number 2, by taking the law in his own hands according to his own choice, whimsically, arbitrarily, and also without any consent from the plaintiff, and as such the defendant conjointly in collusion and connivance with each other, and also by engaging some antisocial by hooligans person of the society, and of or by taking in the law in their own hand, have been making attempt to make addition alteration of the factory set as a whole according to their own choice. Number I will show from the written statement of the defendant number 1 and defendant number 2, there is a categorical statement that we are in possession. I am showing to your lordship, my lord, the statement, my lord, in the written statement. But kindly see the written statement filed by Jayantu Das. Madam, may I just page 6 of the written statement, my lord, if your lordship consider. Written statement
Defend number 2,
filed by defendant number 2, Joyanto Das.
para 10.
Page 6, my lord. Because, my lord, if I read the entire, my lord,
Page 6 is paragraph 10.
page 6 is, my lord, paragraph 10. Yes, my lord.
Yes.
But if your lordship see once, my lord, from 7 line from top, the word starts with in May 2007. In May 2007, the proposal for formation of a partnership business with defendant number 2 was disclosed to Srimati Abha Chatterjee, who consented the same and accepted rent up to April 2007. But plaintiffs claim the property through Abha Chatterjee. Srimati Chatterjee is a noble and precious lady, and she cannot dispute the matter of the partnership. Since the defendant number 2, as a working partner and also a finance in the business, the question of transfer to the tenanted premises to the defendant number 2 does not arise at all. It is also disputed that the defendant have taken up any repairing work in the suit property, and the defendant did not object to the appointment of the local inspection commission. The entrance gate of the suit premises and the pillars and walls are in serious condition caused due to the last incident rainfall, and the same is lying in the same state. The plaintiff are dubious persons and are making wild allegations against the defendants in paragraph 7 and 8. The plaintiffs are to prove thereon. Now, my lord, I have stated that from the beginning, with the consent of the previous owner, my lord, I am in possession. It is a partnership business. Now, my lord, this written statement, after receiving the written statement also, he choose not to amend the, my lord, plaint. If your lordship see the amended written statement, my lord, in the amended written statement, if your lordship see, but in paragraph 9, page 3,
Mr. Mukherjee, the line from which you commenced, prior to that line,
but
prior to the line, in May 2007, prior to that one.
but in original written statement,
No, the amended written statement.
amended written statement. My amended written statement, your lordship is referring, my lord?
Page 6.
Page 6.
Yes, my lord, page 6.
You started from in May 2007, just prior to that line. It is denied that.
But in amended written statement, page 6, my lord, what I read, my lord, that is from the original written statement.
So what was the decree? So what you are trying to say is that there's no question of subletting because a partnership came into existence, and by virtue of the partnership, both are in joint possession.
And not only that, they had accepted the rent that I have
And you
stated.
say we have given a copy of the partnership deed. After that, they have been accepting rent. Then they have filed the suit. These facts have come into
Now,
being during the suit. Still, no steps have been taken.
now, what I want to say before your lordship knows, my lord, section 34 of the Specific Relief Act, a person is entitled some relief under this act. The person, my lord, has filed a suit for declaration, and this is the suit for declaration injunction. But he has a consequence of relief or recovery of possession. If he has not paid for relief in the earlier suit, there is a judgment, my lord, I will show, if your lordship permit, my lord, in latter suit, he cannot pay the same said relief.
So what was the prayer in this suit?
Case. Now, my lord, kindly see the plaint. The prayer, your lordship will find at page 10. Now, kindly see the prayer. Kindly see the prayer in the suit at page 10. A decree for a decree for declaration that the plaintiffs are the absolute owner of the property mentioned and described in the schedule herein below, and the defendant number 1 is a tenant under the plaintiff, with a further declaration that the defendants have no right, manner, right to change the nature and character of the suit property mentioned and described in the schedule below, and or defendant number 1 have no right to sublet the defendant number 2 over the property. Causing for a moment, first relief is declaration that the plaintiff are the absolute owner. Second relief is that declared that the defendant number 1 is the tenant. And third relief is that restraining the defendant number 1 from subletting. Although the statement has been made that we are jointly a partnership business and you have accepted the rent. But this is the principal relief which has been sought for in the earlier suit. Now, kindly see once section 34. Proviso. May I just hand over, my lord? Just a second. Just a second. But section 34 starts with discretion of court as to the declaration of status or right. Any person entitled to any legal character or to any right as to any person may institute a suit against any person denying or interested to deny his title to such character or title, and the court may, in a discretion make a therein a declaration that he is so entitled, and the plaintiff need not to such suit ask for any further relief. Kindly see provided that no court shall make any such declaration where the plaintiff being able to seek further relief than a mere declaration of title omits to do so. Therefore, my lord, what is my understanding that, my lord, if he wants to get further relief, he has to pay in that suit, not in latter suit. And if he omits to pay that relief in latter suit, he cannot. He can if he take the leave under order to rule 2 in subsequent suit. May I? Now, my lord, if your lordship consider order to rule 2 of the Code of Civil Procedure, but the leave has to be taken from the court. There must be a relief in the plaint. There must be a prayer in the subsequent plaint to grant me leave to file the present suit. Justice Bhattacharya, my lord, have his my lord proviso. Now, my lord, kindly see the second. Now, kindly see the present plaint. Title suit number 30 of 2009. May I just once interrupt one point I have forgotten to tell your lordship, but this suit has been dismissed on 22nd December 2016. But certificate copy I have already handed over before your lordship. Second,
83.
No, 22nd December 2016. Yes, 83. Yes, my lord.
22nd.
22nd December 2016.
Yes.
The certificate copy has already been handed over, my lord. If you lordship wants, my lord, I can also produce.
No, if it is here, why should it?
With the punch of the entire order sheet, my lord.
Yes. Yes, we have.
Yes. Now, my lord, during pendency of that earlier suit, the present suit has been filed on in 2009.
Yes.
Now, my lord, if you lordship see the plaint of present title suit 30 of 2009.
Yes.
But in 30 of 2009, with
Yes.
I have a lordship got the plaint of TS.
Yes, we have got it.
In title suit number 30 of 2009, with due respect, very cleverly, the suit of pendency of the earlier suit has not been mentioned. If your lordship consider the plaint, rather only in paragraph 11, my lord, if your lordship consider, they have virtually admitted subtenancy. It should be the plaintiff beg to state that the plaintiff previously apprehending the mischief of the defendant have brought a suit for declaration and injunction against the defendant tenant, namely Messrs. Ananta Engineering Stores, as well as the said person, namely Jayanto Das alias Hora, wherein this landed court was pleased to pass an order of status quo, but unfortunately, despite the said order, defendant tenant has brought the said person in the property in question. Now, Justice Bhattacharya was of the opinion that in earlier suit they have not stated that I am going to subtenant, create the tenancy, but in during pendency of that suit in 2009, they themselves admitted.
Why the issue of res sub judice was not raised?
Yes, that I'm showing to your lordship. This point was earlier raised by your lordship, and I have showed the written statement. I will show. I'm coming to that. But your lordship has kindly see, my lord, I'm giving the reply to Justice Bhattacharya. My lord, kindly give me 1 minute, my lord. But kindly see the prayer of the plaintiff. But this question has been put by your lordship on the last occasion when the matter was heard. But the simplicity of prayer is a decree for eviction and recovery of khas position against the defendant. No prayer for leave under order to rule 2. Now, my lord, the reply of Justice Bhattacharya, my lord, if your lordship see, my lord, my written statement. My written statement, my lord, I have handed over last occasion, my lord. Along with the plaint, it will be. But page 3, my lord.
Referring to para 7.
It continuation of paragraph 7, yes, my lord. Kindly see page 3. I have mentioned 2 points. One, Jointodas is a necessary party and proper party. And second, earlier suit. Now then, my lord, Justice Prasad asked me whether you have taken the point of order to rule 2 in the earlier written statement. Now, my lord, kindly see, my lord, my additional written statement.
Yes, paragraph 4.
Now, this point has not been considered by either by the trial court or appeal court. Now, that's why, my lord, although, my lord, that's why your lordship asked me to prepare a grounds, my lord, that I have handed over. Now, I realize the judgment of the Supreme Court, my lord. But I have handed over 2024 volume 5 Supreme Court cases, page 282. Page 282. But it says declaratory suit without consequences and relief regarding maintenance. But if you actually consider paragraph 49, previously the proviso was not there in the specific relief act. Now, my lord, the legislature was of the view that to minimize the litigation, this proviso has to be included. That has been considered in paragraph 49. And in this judgment, my lord, it has been held by the Honorable Apex Court that, my lord, if the relief which the plaintiff is entitled has not been paid for in latter suit, he cannot claim. In paragraph 50, your lordship will find the other judgment of the Honorable Apex Court has also been considered. And next, I will rely regarding the leave and order to rule 2. They ought to have taken the leave. That judgment I have also handed over 2019 volume 6 Supreme Court cases 621.
Wipe it.
Yes.
Last time I have given
19.6.
19.6. Page 621. Yeah, it has been held that if any relief has not been sought in earlier suit, then if he want to take that relief in subsequent suit, he ought to have make a prayer under order to rule 2, and his first duty will be to take the leave from the court.
No, but that would apply if he has succeeded in the earlier suit or if he has lost in the earlier suit.
But that's a ultimately, when this judgment has been passed, he lost.
Therefore, we are asking you, since he has failed in the earlier suit,
Now, if I say this way,
if he had succeeded and he had omitted a prayer,
parallelly, he cannot proceed to suit. He is just trying his luck. When he filed the earlier suit 83, in 83 that suit was continuing. Now, your lordship knows, my lord, if I say then my lord, I have taken the specific plea, but the court ought to have considered. And my lord, now my lord, in second suit, my lord, when my lord this the question which is fallen from your lordship, my lord, that my lord, whether when the second suit has been filed, why leave is required because earlier suit is pending. I say section 11 provides that second suit he ought not file. This suit is liable to be dismissed in limited with cost. Now, order to rule 2
This after disposal of the earlier suit. There's judicata.
May I just one second? But suppose today he filed an earlier suit, but he knows the defendant number 2, rather whom he says that the subtenant, but he already entered appearance, he made out his defense, then he knows that it is his defense. But if your lordship permit me to argue this, that he ought to have amended his earlier plaint, he has not done that. He simply proceeded with the earlier suit. Secondly, when the earlier suit was proceeding, now he very cleverly filed the presentation, and very cleverly, I must say, he did not mention the earlier suit number and anything. Only a statement that I have filed a suit. And he virtually, if your lordship consider, the conjointly the paragraph, we have just show to your lordship. Yes,
So according to you, he had not come with clean hand.
a clean hand in civil procedure code, my lord, regarding injunction and others I can't say, but regarding the suit, my clean hand, there is no, my lord, provision that I
Suppression.
and suppression ground, then order 7 rule, that stand I have not taken. That's it. That is also a ground. But my lord, when he has himself stated, if your lordship see once, my lord, paragraph 11 of the present suit, he himself stated that the defendant number 2 has already been subletted. He has been I have created subtenancy. If I put this question to myself, he ought to file an amended plaint or amend his earlier suit, but making this statement. Therefore, he has the knowledge. Number, there is a multiplicity of proceedings. He cannot play with the court. He cannot play with, and moreover, in both the courts did not consider this point at all.
That's why
But
Section 10 CPC.
Latter suit has to be stayed, but that step has also not been taken. Kindly admit that if your lordship thinks, I can't. Last time, if I say, that your lordship is going to reserve the matter for orders to admit, that's why your lordship asked me to bring that order to rule 2 point, because it was not taken. I have handed over that also, my lord. আরেকটা জজ সাহেবের রয়েছে, আর কপি উইথ let us try my luck in this appeal also, my lord.
May I take a my lord, may I take a
Before
limited
admission, he don't have any.
lordship, may I only submit one thing? My lord,
Not.
I will cite one judgment. my
You
lord.
may not, sir.
My lord,
Sorry.
regarding my right of audience, my lord, I want to cite one judgment of the Honorable Supreme Court. I have a
Yes.
limited right, my lord, of hearing. My lord, may I cite that judgment, and then your lordship, if permits me, then I will open my mouth.
For admission,
I will cite one.
Before admission,
my
sir.
lord, I will cite one judgment of Supreme Court on that regard, my lord.
Yes,
That I have
to us.
the judgment delivered by my lord Dr. Kumar Ganguly, my lord, sitting in Honorable High
What was
Court.
the judgment,
My
sir?
lord, I'm sorry.
Sitting in the High Court.
No, my lord, the sitting in the High Court, the judgment which was delivered is against me.
Yes.
Thereafter, my lord Justice Ashok Kumar Ganguly delivered a judgment sitting in the Supreme Court. My lord said that in admission stage also, my lord, have a limited opportunity of hearing. That is cited in my lord.
reference টা কত?
You have given him a copy.
Reference টা কত?
বলছি। My lord, 2011, volume 3, SCC, page 321.
2011,
volume 3, SCC, page 321, para 46.
You don't have the SCC printout.
My lord, that is the my lord, Supreme two-day printout, 2011, volume 3, Supreme, page 665. Your lordship will come to paragraph 46. And after considering that, if your lordship gives me the opportunity of a limited hearing, I will only, my lord, open my
2011
mouth.
column 3.
SCC, page 321. My lord,
But that is not coming with. But 2011 volume.
6,
তাই বল।
6 SCC, page 320. Para 46. But also made it. I will give a very limited reply, my lord.
No, no, regarding interim relief, he is entitled.
No, madam, on the merit of the appeal, but also on the merit of the appeal, page 46. The appellant had appeared and argued the matter not only in relation to the grant of an interim order, but also on the merit of the appeal.
That the interim relief was being taken up.
But also for the merit of the
Yes.
Your lordship,
So at that stage, why not? Who will stop you?
but
When the interim relief is taken up, who will stop you?
If the appeal is admitted, my lord, I
Right.
cannot argue on the merit of the appeal on that stage.
Sir, if the interim relief is taken up, who will stop you from making submission on the merits? Who will stop you?
Actually, the cause of action.
You said you have got a judgment that at this stage prior to admission, you must be heard.
Uh,
Show us where this judgment says so.
Brother, our High Court judgment is
It
against.
is
against me. I am outside. I say.
all right.
At that point of time, the cause of
The
action.
product
But only thing, Monday is the next date. Last time your lordship asked me to pray for adjournment. My learned friend assured that he will not
And I didn't object also.
oppose. A court considered the same. Your lordship fixed on 18 is the date fixed.
Grateful.
Number 3.
Well, this is my application. I am filing my affidavit of service.
You are filing?
My affidavit of service. My lord,
Not attributable, not aggravated.
My-
What the tribunal has done.
my lord, the tribunal lordship has rejected my applications on the grounds. My lord, my disease is, my lord, the epilepsy. It's a neurological deficit, my lord. But by the learned tribunal, my lord, observed it is a mental disorder, and he observed certain judgments, my lord, where the cited the mental disorder is not come within the stress and strain. My lord, lordship, kindly allow me, lordship, to place the case, so I satisfy your lordship. My lord, I was enrolled in the Indian Army on first.
So you have filed a reply before the tribunal. Nothing more is to be filed.
My lord, in the year 1971 on 1st September, my lord, I was enrolled in the Indian Army, and I was invalidated out, my lord, on 4th April 1977. And my such disease, my lord, detected in the month of January 1977, my lord. Just, my lord, after 3 months, my lord, they invalidated me from service. Now, if your lordship kindly come page 101, my lord. If your lordship kindly come page 101, that is my invalidating medical boards.
101.
101 of my my lord, in 103,
No, if we remember correctly, there is some specific provision for mental disorder in the rules or regulations.
my lord, but my lord, my case is subject to lordship's kind correction. It's not a neurological deficit, my lord. It is a lordship that has been granted by the medical officers. My lord, it is not at all a mental disability.
What is the disease?
My lord, the disease is, my lord, epilepsy. My lord, the grant mal epilepsy idiopathic. Pathic. My lord, 103, my lord, where, my lord, the medical board mentioned did the disability exist before entering service? My lord, the answer is no. That has been recorded in the medical board.
Correct. That's why we are saying there is some provision we have seen that says that it cannot be detected at the time of enrollment. In an earlier case, we have come across that provision.
My lord, I provide certain judgments, my lord, on these issues, my lord.
Where are the provisions? Let us see the provision. Judgment will come later.
My lord, the provisions, my lord, as per this medical.
Not detected does not mean not mental. You said there is a finding that is not a mental disorder. Where is that finding?
My lord, that is mentioned, my lord, my lord, that is my case, my lord. My lord,
So there is no finding. You may say that it is not a mental disorder. You may take that ground, but there is no finding either in the medical board nor anywhere.
Nowhere. My lord, they said, my lord, as per the entitlement rules, my lord, they mentioned if they hold that he cannot be that has been detected at the time of the entry because of
They don't have to hold. There is a provision.
my lord, there is provisions in these entitlement rules.
Where is that? Let us see. That's what we are saying. We have come across that provision in a case earlier.
My lord, pardon me, my lord, because it is a very illegible, my lord. একটু সাইডে দেবেন হ্যাঁ না আমি বলে দিচ্ছি এটা একটু দিন সাহেবকে দিন এটা বার করে দিলাম পেজ এই পেজটা বার করে দিলাম
Should be here. Should be here. We should have it. Yes, clause 14, correct.
My lord, 14, my lord, subclause B. There has to be a reasons, my lord.
This is the up-to-date provision.
No, my lord. My lord, the same provisions are there. My lord, they are relied upon.
Where is the latest provisions?
My submissions, my lord. These entitlement rules have been relied by my learned friend in his affidavit in opposition.
What is the date of this medical board proceeding?
My lord, that is lodged in 1977, my lord. At the time of
77. Then how 82, 83 can apply in 77?
My lord, after that, my lord.
Madam, please try to understand.
Well, after that,
how a rule of 82 or 83 can apply in 1977?
My lord, after that, my lord, I preferred in one original applications. After on the basis of that, my lord, another board was conducted.
Board entitlement, can it be considered with reference to an 83 provision?
My lord, after that, my lord, 2008.
So in 1977, whatever has happened will be considered under 83 rule.
My lord, after that, my lord, there is
very nice.
My lord, because my learned friend also relying upon this board and this.
What is the forget about who is relying upon what? We are on a legal issue.
My lord.
Just because they have relied, it does not mean it is correct. Or just because you have relied, it does not mean it is correct. It's a board of 77. What was the rule governing the board at that time? How 83 or any subsequent rule or regulation can be relied?
After that, another board was conducted.
We don't know. We want to see. We want to see. Subsequent board means nothing.
My lord, they on the basis of that, my lord, I prefer before the lordship.
Just now you are referring to 101.
That is my initial of my submissions, my lord, because this is the initial board. After that, my lord, on the basis of that, my lord, I preferred the disability pension. They rejected my prayer on the basis that that is neither attributable nor aggravated without assigning any reasons.
This is the only board.
No, my lord. This is not the only board. Well, after
Where
But
is
the
the second?
reassessment board, my lord, that is paid.
Reassessment board is not a medical board.
Well, that is not the
It is a review. It is a review medical.
My lord, on the basis of that.
Review is not the original board. Show us the original provision applicable in 77. How a review medical board can be? It is just
My
to
lord-
assess whether the earlier thing was done in
My
accordance
lord,
with
if
law or
that is
not.
so, my lord, kindly come to allow me to place the observations of my the learned tribunal, my lord.
No. Tribunal will see last. First show us, satisfy us. What is the issue? Why should we go to tribunal's order? You are impugning and you want us to see the tribunal's order.
My lord,
According to you, tribunal's order is incorrect. According to you, the tribunal's order is incorrect.
Incorrect.
So we are trying to see first for ourselves what it should be. Then we'll see the tribunal's order. 77 matter and you are referring to 83 regulation.
My lord, that is the
Cannot be
information.
done.
My lord, on the basis of that,
You are only relying on that, then there is nothing.
my lord, if that be so, my lord, another lordship, can they allow me lordship to place?
Show the contemporaneous rule or provision.
My
You
lord, at
cannot
this
get over
moment,
it.
my lord, regarding lordship in the year
Oh,
1977.
it is impossible.
No, my lord, at this moment, my lord, give me some time, then I will try
Come
to
back
lordship.
with it. Say that. How much time it will take? Hardly 2 days.
My lord, it will.
Books are available everywhere. What is the big deal?
My lord, in the year entitlement rules.
You are saying as if now you have to go search somewhere in the archives. These rules are available everywhere. It must be there in many libraries. It's not a difficult thing. Every day we are coming across old acts and rules. And it's not so ancient. It's something of 77. You have to show it. How can we rely on an 83 rule? Cannot be. Give this rule back. Give this back.
Retaining the same.
Call the next case. Yes, retaining its position. You may.
As your lord.
Therefore,
Our service has not been completed.
Not required. Why service is
Missed the brief. The fact is that I missed.
not today?
five,
Kindly give permission to not today. So,
Why, sir?
as the learned senior advocate Ashok Kumar Bhumik.
All right, not today. Call the next. Yes, next call.
six,
Come for the respondent.
Not today.
seven,
Please, your lordships. The short extent of my prayer is that my maintainability application, the learned cat wants to hear with the OA. Your lordships are directed I had come before your lordships on an appeal from a vacating application. So your lordships had directed that your maintainability application is there before the CAT, and it's a matter of a week. Let the CAT hear the maintainability application. Your lordships had disposed of that writ. Now your lordships would kindly look at your lordships' directions before the impugned order. They want to, my lord, hear the OA. Your lordships would kindly consider your lordship's order at page 138. This is a matter, Millards, where the transfer, Millard, your lordship's order is at 138. Annexure P5. And Millards would kindly see para 5 at page 139. Your lordships direct the CAT to dispose of my maintainability application.
For hearing on 18.
That is exactly my point, Millard. The OA has been fixed. Now I am being arm twisted to argue the OA. My limited prayer today, Millard, is my maintainability application be heard before the OA is heard. Because, Millard, today the issue is whether the CAT.
Oh, 18 fixed করেছে 18 সপ্তাহে শুরু হবে।
Millard, the issue on maintainability.
So the issue is that whether legally you are entitled to a consideration of the maintainability aspect first.
Gotcha. May I place the judgments?
Let us see.
May I kindly place the judgments?
Or both issues can be decided together.
Together. Now, Millard, may I first place just two judgments? I know your lordships do not like multiplicity of judgments. So
It doesn't, it's not fruitful. It's not that we don't like. If it is,
which is why, Millard, I will not burden your lordships with 1999 6 SCC 632. Your lordships could straight away come to para 9. And just on the facts, Millard, in my case, the CAT is entertaining a petition which challenges a transfer policy simpliciter. There is no challenge to a transfer order.
That's on merit.
Therefore, no, that is on maintainability.
therefore, then the issues are interlinked.
That is my point, Millard, because
So therefore, if that is your objection, then they will have to see whether it is a matter which can be entertained on merits or not.
Millard would
So then-
kindly look at my maintainability petition.
Yes,
Your lordship would kindly
we have
look at
seen
my-
it on the earlier occasion. After that, we have directed that it will be considered
It
by
will be
the-
considered. Now, Millard, the matter went up before the Honorable CAT. Your lordships have seen the impugned order. They could have disposed of my
This is the
maintainability
impugned
application.
order. We have not seen, let us see, just give us 2 minutes.
Yes.
And that same policy is pending consideration in the High Court
Millard,
also.
the erstwhile policy, so a transfer order under an erstwhile policy is pending consideration. So,
WPCT 167.
yes, that is a transfer order pertaining to an erstwhile transfer policy. Here, in this matter, only a transfer policy, the subsequent transfer policy has been challenged. Millard would kindly produce my MA. It's a short MA at page 131. It's a very short MA. Paras 2 and 3, my lord. 134, 135. I'll thereafter come to the judgments, my lord, but I just wanted to satisfy your lordship on this point. Yeah, I only take your lordships through one page. Millards would kindly see what I'm praying for at page 10, prayer B. Page 10 of my writ petition at prayer B. That's all I'm seeking, your lordships. I will paste those two judgments. Because if the maintainability issue is decided in my favor, my lord, then I do not need to go into the nitty-gritties of the OA. Today, the learned cat has to decide whether it can have a judicial review of a transfer policy simpliciter. Millards would kindly see page 10 of my OA, and I'll place the two judgments. Lordship. Millards, have that first judgment that I have placed, 1999 Supreme Court. May I kindly place para 9? Specifically, just 2 lines above placitum F, Millard, but just for context, may I place the whole paragraph? If a ban contained in the third proviso to section 11.3 of the Act, that was the Kerala Rent Control Act that time, applies, its corollary is that the petition filed by the landlord has to be expelled on the sole ground that the landlord was then not entitled to file it. In such a situation, the court should not enter into the merits, because whatever is said or found on the merits would then be without jurisdiction. The High Court, and this is what I'm relying on, Millards, the High Court should have first decided the question of maintainability of the petition, and only if that point was found in the affirmative, the merits need have been gone into.
Has the provision 11.3 been quoted?
Yes, Milord.
Where is it?
It has. Your lordship would see para 3. The landlord could not have filed a petition for eviction within a year from the date of the instrument, and the landlord does it. In fact, my lords, para 4 is relevant because the proviso is what is in contention here.
So it was filed within less than a year.
Less than a year. So my lords would see para 9, and the finding and the ultimate holding is at paragraph 19. My lord, I am also relying on paragraph 19. Just 2 lines below placitum C, if I may place that. Any observation made on the merits of the case in the proceedings based on such a non-maintainable petition must stand erased from judicial notice. That is what I'm submitting, Millard, that unless they dispose of my MA, good, bad, indifferent. Because I know the mentality of the unlearned cat from the hearing that took place when I went there. My MA is going to be dismissed. I have to approach your lordships. because the learned cat wants to take up the matter. Good, bad, indifferent, my lord, they should dispose of. My lord, may I kindly place the second judgment?
Yes.
It's reported in 2002, Volume 1 SCC 475. I'm relying, my lord, on paragraph 5 and 6 specifically, but paragraph 5. May I place the paragraphs, my lords?
Yes.
This is exactly why, my lord, your lordships did not interfere with the previous order granting stay. Your lordship said that your maintainability application will be decided. So the fate of the maintainability application will perhaps decide what my fate will be in the OA. My lord, I am only relying on paragraph 6, just above placidum, just below placidum F. We think it is just and fair, but we should not at this point interfere with the impugned order, though the High Court could have avoided passing such orders in proceedings where the maintainability itself was being seriously questioned. Be that as it may, so on. The para B is, my lord, of my petition is the limited extent. The matter is there on the 18th when the cat wants to hear the OA with the MA. My purpose will be defeated, my lord. That's my submission.
Yes.
Whether he can maintain this writ petition. Well, this honorable court earlier passed an order that's very clear. Have to turn to page 138. And this is being encouraged by a public authority. That also, my lord, would can consideration. At page 189, paragraph 3 of the order passed by this bench, we have made a specific query as to whether the pleadings have been exchanged between the parties, to which the reply is that yes. The reply has been filed, joined as well. If of such situation, matter is to be taken up within a week. We find no reason to interfere with the impugned order disposing of the petitioner's earlier MA, carrying MA number such and such. We only record that it is expected that the tribunal shall proceed to consider MA expeditiously without unnecessary delay or undue adjournments. Now the tribunal, after having considered this, said that I shall dispose of both MA and OA on 18th of August. How could he challenge this? And whether the judgment which is citing, deepest of respect, does not have any application. My lord are well aware, Order 7 rule 11 principle applies. The question when the jurisdiction of the court is questioned, then that has to be decided first. Here he does not challenge that the tribunal doesn't have a jurisdiction to entertain. Whether this is judicially permissible for review or not, that's on merit.
Whether it comes within the scope of judicial review or not,
that's a matter of merit. That's not a matter of jurisdiction. Therefore, the 18th is a date fixed. Let him go there and argue.
Millard, I'm sorry if I'm.
Tribunal has clear opinion. He will hear both the petitions.
Millard, just to answer Mr. Bhattacharya's point.
So where is, under which provision there is a bar? Show us.
The bar is because of the judgments, because I am.
Like section 21, there is a bar.
Yes, Millard.
Read section 21. 20 and 21, there is a bar. 20 is ordinarily a bar and 21 is a bar. Now, that kind of bar, where is it applicable to the case in question?
Lordship, may I kindly take Millards through this?
Section 20 says ordinarily it should not be done. So it's not an absolute bar. Section 21 says there is the tribunal shall not admit. So where is because 11.3 is in the line of 21, akin to section 21 here. So if there is an issue of limitation, like you have relied on the other case, obviously the court will not have jurisdiction unless limitation is decided.
But here, Millard, I am not. Mr. Bhattacharya's point was whether I am challenging the jurisdiction or not. Millard, with the deepest of respect, I am challenging the subject matter jurisdiction.
Yes, yes. See that whatever you are saying,
yes,
Normally, those principles govern our judicial review also. That in matters of policy, the court normally refrains from entering into. These are matters left best to the authorities. The same law applies to a transfer. It's not that transfers are not being impugned every day. They may not succeed, but can the court be prevented from looking into it? That is the issue that you are trying to raise, that court should not look into it. How can you say that? Where is the bar? So we asked you. Either there is a bar or there is no bar. It's an issue of law.
Schedule Millard was
What do you want? You want to act?
Millard, I'm yes.
You may have it. No
I,
problem.
I profusely apologize
Please, we'll
for
refer
the
to it.
inconvenience, Millard. The schedule, Millard. Schedule.
Sound exercise of discussions and it's not that there's an absolute bar. See, 21, section 21, what section 21 shall not end. So if this is pending, shall
Let's
not
add tonight.
moderately admit. So this is something that circumstance do not. This is another here. Still they have filed this right. Some of the debts before the you are referring to some provision.
Yes, Millard. Appendix 1, Millard, of the CAT rules of practice, which derives from Rule 18C, Millard, it all relates to Section 14. Your lordships would kindly consider the kind of cases that the CAT can deal with, and here, Millard, cases relating to postings oblique transfer. That, Millard, would mean a transfer order in my submission and not a transfer policy. Millard would kindly see.
Can you give us the page number?
Yes, Millard.
Give us the page number. You keep it.
Page 94, Millard, of this, the schedule.
Yes.
What the division bench can deal with is 1 and 2, matters involving statutory provisions, so on and so forth, provisions of the Constitution. Millard, the single bench, your lordships would kindly see the schedule. It says cases relating to postings oblique transfer.
This is allocation of business.
Allocation
This
of
is not dealing with jurisdiction of the forum. This is allocation of business. This is a different thing. All right.
the transfer policy.
We have understood. Unless you have something else to say.
Transfer policy, Millard, I had judgments.
We don't know. We don't know the tribunal whether it is going to allow or not allow. We don't know. We are not there yet.
But on the maintainability
And
issue,
we are
that-
not going to take it up directly. You know the limitation.
which is why, Millard, I didn't place the
L. Chandra
judgments on
Kumar,
policy.
and now there is one more judgment, 2010 4 SCC 554. There are two judgments that arose out of this court.
Which is
Then
why,
for
Millard,
SCC 5.
I didn't place the matters regarding policy of whether the tribunal can take up or not before your lordships today, because that is probably something that I'll place when I come up in appeal. When my
See, we don't know whether you like.
But my
You
place-
feel so, but we don't know.
maybe I will be very lucky if the tribunal rules in my favor, Millard.
We don't.
I will be perhaps personally I will be luckier if the tribunal does not rule in my favor, because I'll earn another fees. But Millard, that, apart from that, Millard, today the maintainability application is decided by the CAT before the OA. Then, my lord, my purpose will be solved. If the OA is taken up, then there is no point to the MA, Millard. Then there
Yes.
is no point to the
Heard learned advocate for the
My lord, service upon the respondent is not completed, my lord, as I am paying for no.
Not required, sir. Let us see whether we need them or not.
Senior counsel, Mr. D.N. Roy is also not present at today.
Not today. Ask him to be here.
Fine.
Petition has been filed with an innocuous prayer for enhancement of rate of interest, which has been granted by the learned tribunal. My petitioner before your lordship was
Payment was delayed on what payment was delayed?
the entire due, entire retirement due, pension, gratuity, everything.
When did you retire?
I retired in 31st October 2014. There was a disciplinary proceeding that was concluded in 2022, wherein I have been discharged from the charge that was leveled against me.
Yes.
On only innocuous prayer, learned tribunal has been pleased to granted interest at the rate of 6%. I have come before your lordship to enhance that because there was no fault on my part. I was suspended, then a disciplinary proceeding was initiated, and ultimately.
So the retirement dues have been paid to you now?
Yes, that.
When?
In 2024.
Huh?
In 2024, probably.
2 years after the discharge?
No, I was discharged in 2022.
So therefore, if you say paid in 24, that means 2 years after discharge.
I am referring the pension payment order 2023 and 2024 in part payment has been made. The pension payment order appears at page 16 and 17.
And the proceedings were finally closed on which date?
On 15th December 2022.
Any interest or not? As of now, how do we know that you will get any interest?
I retired in 2024.
Huh?
I retired in 2014.
No, but see the order, you are saying only insofar as the rate of interest.
Yes, sir.
The order does not direct to pay interest. Only if the BDO is satisfied that he was at laches, then any issue may arise.
Kindly permit me to take the order passed by the learned tribunal.
You please do it.
Looking at the submission of the both the sides, respondent number 5 video to such and such directed to consider the representation filed before him by the applicant such and such. If after examination of the records, the video is satisfied that due to laches on this part of such.
Correct. So only if he is satisfied, otherwise there may be no cause for interest at all.
Action be taken or awarding interest at the rate of because the page, but if your lordship kindly turns to page. Page 34.
Yes.
Page 34 of my merit petition where says that I have been discharged, the label could not be proved, the allegation labeled against me could not be proved. The learned tribunal has been pleased to pass an order directing in the event I am entitled to get the retirement benefit, 6% interest to be given on my payment. This is the contention of the tribunal.
No, it is not. That is not the contention that if you are entitled to retirement benefits, there is no issue. You are entitled to retirement benefits. The issue is if the BDO finds that he has delayed, then only he will give interest. If he finds that there is no delay on his part, he will not give the interest.
In that event, only keep that point open so that I can come up with the because.
But you are raised. That's why we are wondering how you are raising an issue only about the interest rate.
Because honorably, I have been acquitted. The disciplinary authority could not prove the charge.
And how the BDO can decide, a judge in his own cause?
But the order was passed on the basis of the submissions made on behalf of the petitioner. Lordship, kindly have a look whether the order is.
The petitioner did not say that he will decide.
No, petitioner said that.
Petitioner said that I get interest, not whether I am entitled to interest or not.
May I tell? Lordship, kindly have a look at the order passed.
Please read. Please read.
The third paragraph.
Yes.
The Pal Learned Counsel for the petitioner presents a copy of statement showing in chronological order different dates on which the payments of pension, gratuity, leave salary, and area salary were released belatedly. Mr. Pal submits, it will suffice if a direction is given to the respondent authorities to consider the representation filed by the applicant before the respondent authorities, praying for such interest on the delayed payment of the benefit.
Yes, not praying for a determination whether he will be entitled to interest or not. The tribunal has gone one step back. It says now the BDO will decide whether he is entitled to any interest or not. How such an order can be passed that you are remitting it to the authority to examine whether he has committed a mistake and he is liable to pay interest or not?
I think that order was passed on the basis of the same. That
we can't think, we can only go by what is there. We can only go by what is there in the order. We don't know what he was thinking.
On the basis of the submission that I have filed a representation, let that be considered by the authority concerned. That was their submission recorded herein. Number of the orders could have been passed. That very good. This representation be considered in accordance with law.
In accordance with law, yes.
Yes.
That
I agree.
I
agree. Very good, since both parties agree that the representation be considered.
Where is the representation, sir?
That appears at page 47 and 48. Page 48, paragraph 5 is the relevant portion.
Page 48.
And he simply came for interest, not rate of interest also mentioned there. Whatever he is, the entitled.
No, does the see? That's why we are saying there must be dues of pension, there must be dues of provident fund, there must be dues of.
Since when there is pension, no provident fund.
All right, so no
gratuity.
Gratuity. So there must be some rule or provision governing the grant of interest on gratuity.
Well, so far interest of gratuity is concerned, if it is under the the Payment of Gratuity Act, then, my lord, I think, my lord, there is a provision in the
The
payment of
interest
gratuity act.
applicable to deposits.
Section 8 says that, my lord, there should be, my lord, a representation, or, my lord, the matter should be brought to the notice of the authority concerned. And then, my lord, that will be taken up with regard to the payment of delayed payment interest. But that is, my lord, under the Payment of Gratuity Act. And there, the, my lord, provision of interest also there.
Normally, the rules have a provision regarding grant of interest in case of delay by the authorities. Under the railway service pension rules, we saw that it said in such a circumstance, if he is honorably discharged or acquitted, then it has to be presumed that it became payable on the date of his retirement.
So for the recovery of gratuity, section 8 says, will also kindly have a look. And for the competent also can একটাই বই আছে and a single copy lordship.
Recovery, where is the issue?
The section 8 speaks about that recovery of gratuity when delayed payment is concerned. There is a provision regarding payment of interest. But that too, as per the rate, my lord, fixed by the central government.
So therefore, we ask you, there must be a statutory rate prescribed. Beyond that, whether he can claim or not.
My lord, may I tell lordship, my lord, so far this type of gratuity is concerned, where there is, my lord, no pensionable gratuity, but the provident fund standards, then, my lord, I think the gratuity act is applicable. But so far the
On your thought, we cannot proceed. We want to see.
my lord, then, my lord, may I, madam, I have to, my lord, take instruction from the department with regard to, but normally, my lord, 6% interest is awarded.
Our High Court is giving about 10 to 8
statutory.
10% I have never seen.
8 settled.
Sometimes 6%, sometimes 7%. Mala, so far my knowledge is concerned, mala, it is awarded. But in the present case, lordship, mala, kindly consider one thing, that because of the, my lord, dependency of that proceedings, then, mala, the WBSR, West Bengal service rules say that, my lord, only a certain portion can be paid when the proceeding is pending, not the entire amount. So during the pendency,
There is one compilation of DCRB also.
during that pendency. If your lordship kindly allow, I can come back on the next day, because
All right, let us see what it is.
yes,
Come back.
but it is my duty to assist your lordship on this issue, my lord.
The
much.
Lordship, I am for the petitioner. I am led by Mr. Subhashish Chatterjee. He is engaged in another court. Therefore, I am paying for not today.
This was called yesterday also.
I don't know.
Yesterday college.
Let him first, not today.
Grateful, my lord.
Item 11.
Item 11, Lordship, I beg to appear on behalf of the applicant.
Phone number 6, 7, and 8.
Nitai Charan Manna.
General of OA.
You want gratuity to carry an interest of Bajaj Finserv?
That was only relied upon to prove that at that particular relevant point.
Views are to be governed by the statutory provisions. You cannot travel beyond that.
Lordship, the grievance of the petitioner was that she was awarded 5% interest. 5% interest. The petitioner's husband died in the year 2008. Benefits were released in 2021.
Yes.
And Lordship, the grievance is that the delayed payment, Lordship, interest was calculated at the rate of 5%. Petitioner has made claims of a larger sum, but Lordship, I shall restrict it to the prevalent interest rate at that point of time. And that is why, Lordship, at that Bajaj Finserv, Lordship will kindly turn to page 76. Because in 2008-9, Lordship, the rate of interest on fixed deposit was 7.75 to 8.5. That is only for reference that it was placed before the before the learned tribunal.
Was any reply filed before the tribunal?
No reply, Lordship. There was a supplementary affidavit, Lordship, that encapsulates my case, Lordship.
No, we are asking you whether the respondents therein had filed a reply or it was disposed of. Then we have to give them an opportunity before we proceed. Who you are appearing? Let an opposition be filed to the affidavit of service taken on record.
I have already been expunged, my lord. Accountant General of India, my lord. I have no role in this matter. This is purely on the state government matter, my lord. My name can be expunged, my lord. 6, 7, and
From that side, sir. You are a respondent. Your name has, you are impleaded here also. Although you were expunged from the tribunal. Why did you make him a party? Yes. Yes, is there any dispute on this? It is not in dispute.
Your Lordship, in this matter, I am led by Mr. Advocate Shomo Dashgupta, who is not well to come before this court. I am praying for not today, Your Lordship.
All right, not good.
The 13.
I beg to appear for the respondent. Hmm.
Item 13.
No. 13, let us pass an order. Yes, 13, you pass an order.
Item 14.
Here on behalf of the petitioner. Could your Lordship, Millard, long pending matter? Now, just I indicate to my lords about the factual matrix, then your lordships may look into the judgment. I was appointed as a substitute peon,
Railways.
railways. Millard, I have brought also the railway manual, Millard. Now, I was absent for the period from 31/7/1988 to 22/1/1990. This period I was absent
And this substitute? What
as
is
a substitute peon.
peon?
Then, Millard, I was absent for the period from 31/7/1988 to 22/1/1990. This period I was absent. Now, Millard, accordingly, Millard, 2 charge sheets had been issued, Millard, on the ground of unauthorized absence in respect of the same period. Kindly consider that in respect of the same period, that is 31/7/1988 to 22/1/1990, 2 charge sheets were issued that I was on unauthorized absence. Then I challenged the validity of the charge sheet, Millard, before the Central Administrative Tribunal. Now, the Central Administrative Tribunal passed an order, which my lords will be pleased to find at page 21 of the present petition. This order was passed on 21/7/1997.
What is the OA number?
The OA number is 358 of 1991. Process will be pleased to find the order from page 21 to 23. Millard, I just, in order to cut short the time, Millard, I just appeal to my lords that your lordship may kindly come to paragraph 6 at page 23. In view of the above, the charge sheet dated such and such
are both quashed and set aside, along with the order of the inquiry undertaken by the respondents. However, since the charges leveled against the applicant are serious, namely unauthorized absence for a long time, we give liberty to the respondents to proceed as per law against the applicant if they so like. We further direct the respondent to treat the period as per rule, and a decision should be conveyed to the applicant within a period of 2 months from the date of communication. Mr. Ghosh submits that the applicant was not allowed earlier to join. Now he wants to join. If the applicant wants to join now, his case shall be considered by the respondents in accordance with law.
So both charge sheets were quashed?
Yes. Because these were of the same period for which I was on unauthorized leave.
So the second could not have been done. Why the first was also quashed?
Miller?
The second charge memo for the same allegation.
This is not sustainable.
Then why the first was quashed?
Miller, this primarily Millard was quashed because Millard.
Anyway, that is now it is an accepted fact.
It has attained a finality.
All right. Yes.
Now Millard, after this incident, now Millard, I was reinstated on service.
After passing of the order by the tribunal.
This was done. I was reinstated in service on 15/12/1997. 1997. 15/12/1997.
The date of this order?
Millard, this order was passed on
21/7/97.
Yes, I'm grateful. 21/7/1997.
So you remained in suspension for 7 years.
Now, I show to my Lord Miller the other parts of the matter. Then I was posted as a substitute. I was posted as a substitute peon on 2/1/1998.
Yes.
Then, Mirad, your lordships may kindly consider that at page 27 of the writ petition, your lordships will be pleased to find there is an order. There is an order that at page 27, I was informed that there cannot be regularization of the unauthorized absence.
Page 27.
Page 27.
What is the date of the document? 30th of August 2020. All right. So in my brief, it is 28. In his lordship's brief, it is 27. Anyway, yes. So 28. 15/12/1997. Yes.
আমাকে না এটা embarrassment এ ফেলে দিস। Now, Millard, I just read the letter. I do not know Millard. Millard, from the second paragraph, as regards the regularization of unauthorized absence period and payment thereof does not arise since you were absenting without any intimation. Regarding your joining for Group D post will be considered after being medically found fit by the railway doctor. In connection with the above, you are hereby directed to report to this office for further posting subject to compliance of the above condition formalities and other terms and conditions will be followed strictly as per directives of the Honorable Tribunal. My Lord, I do not find, subject to correction of my lords, again at the risk of repetition, I am submitting. Your lordships may kindly consider, my lord, maybe that there may be a wrong reading of my understanding, but I could not find anything, my lord, has gone down into the order of the tribunal in respect of, that is, it starts from page 21 to page 23.
No, that's not pending anymore.
Nothing pending. why there cannot be a regularization of the unauthorized absence after the charge sheets have been quashed? Milord, it remains, Milord,
So obviously, when you went with the order of the tribunal, you probably sought a regularization of the leave period or
yes,
the unauthorized absence period.
yes, yes, yes,
So it is in two parts. They say that we cannot consider right now.
yes.
But regarding joining also, they are saying that there has to be a medical examination and subject to order of the tribunal.
Grateful to my lord.
Yes.
Then, Milord, your lordship may kindly come to, Milord, the second application which I filed, that is number 422 of 2001, that I will be drawing to my lord's kind attention from page 30 of the writ petition. In this writ petition, I prayed for a direction in this particular Milord application which I filed before the learned tribunal. Milord, I prayed for a direction, Milord, to treat me as on duty and to grant salary and other consequential benefits. Now, Milord, kindly see the judgment which was delivered on 9/1/2008. It starts from page 30. The operative portion starts at page 7, paragraph 7. I stand wrong. It starts from page 32 to 34. Milord, may I place, if your lordship permits me? Page
Yes.
32. We have given our considered view to the arguments advanced and materials placed before us by the learned counsel for both the parties. It is seen from the records that the respondents did not opt to process the disciplinary proceeding against the applicant fresh, though there was a direction of the court to do so. On the contrary, uh, pausing here for a moment, I say I did not find this one, that there was a direction of the court to do so. However, Milord, I proceed what has been.
There was a liberty that having regard to the seriousness of the charge, they may proceed afresh.
Yes, yes. And significant feature which I have shown to my lords, that had it been there was only a liberty given to the respondents to proceed as per law against the applicant if they so like.
Correct. That was taking view the seriousness of the charge. It has recorded.
Absence, therefore. Now, Milord, I just draw to my lord's kind attention from paragraph 7. On the contrary, Milord, last line, on the contrary, the applicant has been placed in a better service condition by giving him fresh appointment in Group D category as peon on regular basis. Now, the contention of the applicant is that he was not unauthorized absent and there was no fault on his part. Therefore, he is entitled to get the back wages. The Honorable Supreme Court in the case of JK Synthetics Limited versus KP Agarwal, reported in 2007, Volume 1, SCC Labor and Service 651, held that award of back wages for the period which he had not worked may amount to rewarding delinquent employee and punishing employees for taking acts as proved misconduct committed by the employee. And also the Honorable Supreme Court held in the case of State of Punjab versus Jagir Singh, reported in 2005, Volume 2, ATJ 179, that the respondents, having regard to totality of the facts and the delinquent employee is not entitled for back wages. The applicant was also not able to produce any materials to prove that he remained absent unauthorizedly for a long period due to no fault on his part, and had it been done, he could not have approached this tribunal during the said period for getting relief. It is an admitted fact that this clearly indicates that the applicant has absented himself on his own way and volition. Therefore, we are of the considered view that the respondents have justified in not granting back wages. However, The applicant's counsel submits that the alleged said period may be reckoned for the purpose. We are of the view that the absented period shall be considered for reckoning of pensionary benefits, if any, as per rules, and the pensionary benefits may be calculated taking into account the periods as well as on the date of his retirement. This benefit shall not be extended for any other purpose except pensionary benefit. It is made clear that this will be available by the applicant if he is otherwise eligible as per pension rules. In the conspectus of the facts and circumstances of the case, we do not intend to interfere in the impugned order. However, considering the given direction by this tribunal and findings that the absented period will be counted for the purpose of pensionary benefits to the applicant at the time of his retirement if he is entitled to as per pension rules. Now, my lord, one thing which I should submit before my lords, that after this judgment was delivered on 9th of January 2008, I find, my lord, that a petition was filed under Article 226 before this Honorable Court.
WPCT 171.
I am grateful to my lord. Page 38.
171.
Page 1. Yes.
We have just gone through.
Page 38.
So now the issue is left open.
Yes. Miller, kindly see Miller for a second, Miller, for my because.
Yes.
Just 1 second, Miller.
With an appropriate proceeding.
Yes. Huh? Yeah. একটু দাঁড়া page 47.
Yes, at page 38, WPCT 171.
Page 38.
Yes.
Miller, page 38. It is an order, Miller, which was passed on 11/8/2008. Yes. Now, this part of this order, Miller, here I find that there is an indication that there has been a subsequent development as the Railway Authority has not extended the pensionary benefit in terms of the order of the learned tribunal. This issue may be brought before the learned tribunal with an appropriate proceeding. Thus, the application is disposed.
Okay. So the writ court was of. It appears the writ court was of the view that when whatever order was passed on the basis of a concession, so whatever you may do it in an appropriate proceeding insofar as regularization of the leave period is concerned.
Now, Miller, two things I should indicate. After reading the brief, but it comes to my mind. As an officer of the court, if your lordship asks me that what is the correct position of the law as on date? As on date, what is the correct position of law in regard to back wages? Starting from today, we are in 25, starting from 2020. The correct position of the law is in respect of back wages. Earlier, Miller, the view was in respect of the persons who are dismissed or Miller, whatever Miller punishment was given. There, Miller, the Supreme Court, Miller, wanted to ascertain as to whether for this particular period you are or you were not doing any work and give us the proof.
Affidavit was to be filed.
Now the law has changed. The law has changed. Now the law which has come is that in respect of back wages, it has now become a discretion of the court, and normally the courts are not giving or not making comments with regard to back wages. This is the correct position of the law, which I have to indicate before my lords as an officer of the court. If I voice on behalf of my client, I have to say that yes, I am entitled to the back wages because of the particular orders passed in the matter. Now, the factum of the case, your lordships may kindly consider.
No, back wages for which period?
Back wages for the period for
Unauthorized absence or after that, after the charge memo was
my
passed?
lord, I join an issue. I say, my lord, that these two charge sheets, my lord, which has been filed and which was quashed, this was for the period for which I was absented, that is from 31/7/1988 to 22/1/1990. Therefore, there cannot be a change of the particular scenario. Had it been a case, because, my lord, your lordships may kindly consider, I have also filed a supplementary affidavit in connection with the matter, wherein I have taken a specific plea. I have pleaded, my lord, I find that I am working till date. Just
No, because that we have just seen. You were placed in a Group D post.
Yes, I am working till date. I am working
That
till
we
date.
have seen.
Therefore, to that, my lord, there is no difficulty, my lord. I cannot say anything.
No, what has happened to that 7-year period?
That has not been done.
Nothing has been done.
My lord, so far কিছু হয়নি তো না হয়েছে?
In between your suspension and quashing of the charge memo, with respect to that period, has any decision
No,
been
not
taken?
not anything has been.
Apart from subsistence allowance, have you got anything for that period?
My lord, I should indicate to my lords, my lord. Then, my lord, your lordships may kindly consider that after this order was passed by this honorable court, my lord, as your lordship has taken note of it, then, my lord, I find that an order was passed on 4th of July 2008. My lord.
Is it on record?
Yes, yes. My lord, that is at page 33 of the supplementary affidavit. The supplementary affidavit which I have affirmed, my lord, that is at my lord, this was affirmed on 28 June 2013. June 2013. My lord, has my lord got it, my lord, the supplementary affidavit?
4/7/2008. What is the date of the document you are relying?
I am relying upon, yes, 4th of July 2008. My lord, this is the last annexure, that is the page 33 of the supplementary affidavit. Now kindly consider this line is very important. Where, my lord, in the first paragraph, after 3 lines, that he had been absenting unauthorizedly since 31/7/1988 to 22/1/1990, and neither submitted any intimation nor did he submit any application for grant of leave. Then his absence for the period with effect from 31/7/1988 to 22/1/1990 has been treated as unauthorized one as per extant rule, and he is not entitled to any pay allowance during the said period of unauthorized absence.
So they are excluding that period.
That period.
That is a break in service as per their.
Right. I am grateful to my lords. Now, one thing I should also indicate to my lords, that my lord, this is.
And this order of 4/7/2008 has not been challenged by you.
Milord, I can.
This 47/2008 order, did you challenge this order?
Milord, I have by way of a supplementary affidavit, I have brought it on record to the judicial notice of the court.
No, it was passed during pendency of the order,
Yes,
matter before the
No,
tribunal or after the tribunal?
Milord, on instructions, I am submitting that kindly consider this particular matter, Milord, when it was this was passed on to though it was passed on 2008, but Milord, having regard to the pendency of the matter before the tribunal, Milord, I say, Milord, that in the interregnum period, Milord, this order was passed. For which, Milord, he had brought it on record for the judicial notice of the court.
What is the date of the impugned order in the present proceeding?
This, Milord, that is 21/7/1997.
No, it is 30th of March 2012.
Milord,
OA 1256 of 2008.
30th of March
2012. So the OA was very much pending when this order was issued. You did not impugn it in the OA.
Milord, page, your lordship is referring to page 40.
The order impugned in the present proceedings.
For 30th
The certified copy.
Yes.
It's of 2012, 4 years after.
2012. Milord, what is there on record? I cannot go beyond that.
So therefore, he did not challenge it in the pending OA.
Yes, that's what I told you. He just brought it on record, and Milord, your lordship may kindly consider that the second paragraph says that he has been treated as an unauthorized one as per extant rule, and he is not entitled to any pay and allowance. And therefore, Milord, the third line is more fatal. The third paragraph, I stand wrong, Milord. In terms of the order passed by the Honorable CAT, in the order dated 9th of January 2008, it is apprised that he is not entitled to pensionary benefits for his aforesaid unauthorized absence period in terms of Rule 1410, 21(1) and 322 of the Railway Services Pension Rules 1993. Now, Milord, I draw to my lord's kind attention that, Milord, about this order which they have referred, that is of 9th of January 2008, Milord, which is at page 30 to 34. Milord, Milord, I say, Milord, with my deepest of respect, that from page 33 of this order, which they have said, Milord, I find, Milord, from paragraph 7 and 8, where is the indication that I am not entitled to the pensionary benefits? Unauthorized absence, this is one part. Unauthorized absence is one part. Even although the order was quashed, the charge sheets, not the order, Milord, the charge sheets have been quashed, but since a liberty was given, they may certainly, Milord, take a view that no, we are not doing
They did not take any action. They did not give you a charge memo afresh.
Right.
But at the same time, you also did not make any endeavors thereafter for regularization of this period of absence. On both sides, nobody has done anything.
Yes.
Because there is an absence of 2 years that is not in dispute.
Now, Milord, your lordship may kindly consider that then this one another OA was filed, that is OA 1256 of 2008. OA 1256.
We'll continue on Monday.
I better discuss the case where paper book is to be prepared. So many
I am the last person.
That may be better to do it.
কতদিনের মধ্যে পেপার বুক করতে পারবি?
Not legible even.
পেপার বুক বলছে, সার্ভিসের কথা বলছে না, একটু বোঝার চেষ্টা কর। আমার ভাই ভুল হচ্ছে বোঝাতে। সাহেব বলছেন পেপার বুক, তুই বলছিস আমি সার্ভিস করেছি।
So when can you do it?
কতদিনের মধ্যে করতে পারবি? 2 সপ্তাহ? Kindly give me 2 weeks time.
For the
We have dismissed.
assigned matter, my lord. This is in furtherance of an assignment order dated 13th of this month, my lord. This is the furtherance of a assignment order on 13th of this month, my lord. This is concerning an recruitment process before this Honorable High Court concerning the Assistant Registrar court recording. My lord, there is another appeal which has been also taken out at the behest of the High Court administration. Both the appeal has been assigned.
This is assigned to this bench.
This is an assignment.
Let us see.
I'm not, Lord, I'm mentioning upon notice of service, my lord.
Hmm?
My lord, may I hand over the assignment notice? I'm carrying a soft copy of this thing. Fourth from the top, my lord. Fourth from the top, my lord. Lord, APO 113 has been taken at the instance of the High Court administration. APOT 124 is at my instance.
My lord. It will come on Thursday.
Grateful, milk.
My lord, what we have today from our learned friend that the original matter will continue. So we
Yes.
rest of the in this appellate side matter, can I expect the order of your lordship's order for release?
Yes, because the court is only till 3:30 today. How long it will continue? Mr. Mitra, it all depends on you.
No, appellate side আছে release
I think it will most probably, yes. Very well. After this only, so most probably, yes.
Side, under reading for judgment, serial number 1, UCO Bank.
Here two for what? 0.02. Huh? Where is and where is the applicant? This GA, where is the file? Not
Under reading appeals from order, serial number 2 and 3, Sajal Datta.
My lord, I appeal for the appellant in the matter.
Now.
My lord, on the last occasion, my lord, I had placed before your lordships, or I concluded by placing, my lord, the order of the company law board of 1999. Now, my lord, I had tried to demonstrate before your lordship, my lord, the observations made by the company law board about, my lord, the
the manner in which manner the respondent pilot or the appellant before your lordship pilot had proceeded. Now, from that manner, your lordships are aware that pilot went before the Honorable Supreme Court, and the Supreme Court order was also placed before your lordship. But may I once again, my lord, show some paragraphs of the Supreme Court order, my lord, which is
Hmm? Yes. Para 40. Yes.
or attempt to materially change the management or control over the company to the detriment of the company. This hospital was floated by Dr. Kumar, Dr. brother, Sajal Kumar, Dr. of Dr. Kumar, Dr. was 4.26. And there was another investment by Dr. Sinha also. If the share of equipment that is rupees 3.5 is not taken into consideration, then the share of Dr. K.K. Doctor is 46.378% and the share of Dr. Sinha 6.365%. The share of comes to share of Doctor is 46.26%. Thus, the company was floating along with his brother for establishing a hospital in the name of his wife. Singapore and all the equipments worth rupees 3.5 were supplied by Dr. Doctor, which were installed in the same hospital. Both equipments were second hand. And this is how the hospital started functioning in 1994. It seems that it started running well, but when it turned the wheel and showed some profitability, it started, which led Dr. Doctor and Dr. Sinha to file a petition. The seat of discord started was passed for infusing some more money often. And it said the same resolution passed. In which Dr. Commander Swanso as director, along with special invitee Dr. Ashok Kumar as director and Mr. Dr. was recommended Dr. Komodpur, Dr. Trupti chair and the chairman of the as the chairman of the other resolutions passed for the demolition of the hospital of the 1995 and in the Minister of West Bengal, maintenance of books, etc. Then my Lord, kindly omit the next part of it. Kindly come to page 47. That's it. Paragraph 47. Well, kindly come to page 36 once, well, at paragraph 46. Paragraph 46, page 36. CLB has, ideal detail, discussed with regard to all resolutions which we have already advertised to. No proper notice was served on appellant number 1, who is a major shareholder of the company, or on the appellant number 2. It would be conveyed without proper service of notice on the appellants by the respondent number 2. Then such board meetings cannot be said to be valid. So also I tried to explain various meetings and their subsequent confirmation by the next board meeting to show that once the resolution of the subsequent meeting has confirmed, the resolution stand confirmed irrespective of the fact that the appellants have been served or not. We shall highlight some of the instances to show that how a subtle attempt was made to show that several notices were given to the major shareholders of the company at their local addresses in India, knowing fully well that both the appellants are inhabitants. The outstanding feature is that appellant number 2, Dr. Singha, has been shown as an inhabitant, but notice to him was sent at the address PO Hirapur district, Dhanbad, Bihar, and since have been sent very short interval. The meeting was convened on 13th April 1996 and the notice was sent on 8th April 1996. 5 days later. Likewise, another meeting was scheduled to be held on 5th September 1996 and the notice was sent on the same day, that is on September 1996. The date of the meeting was 2nd December 1996 and the notice was sent on 20 November 1996. The date of the meeting was 12th March 1996 and the notice was sent on 3rd March 1996. The meeting was to be held on 27th March 1996, but the notice was sent on 22nd March 1996. Apart from this, it was not correspondent schedule. It is the brother of the appellant number 1 that whenever his brother comes to Calcutta, he does not stay in his house. Yet the notices were sent to Jodhpur Park, Calcutta. This shows the lack of probity on the part of the respondent number to somehow or the other oust his brother from the majority shareholder. Similarly, on the basis of such resolution, was ousted from directorship under section 283(1)(g) of the Act. On the ground that he has not attended the meeting and he has no interest whatsoever. Similarly, number 1 also ousted in the meeting, which was held on 7th February 1996. Knowledge of schedule that his brother was likely to attend certain appellant of his chair as a committee. It's scheduled of the in case of Dr. And the minutes of the same meeting dated 7th February 1996 were not brought forward in the meeting of 16th February 1996, in which Dr. K.P. Dokku was present. The ITBI nominee reported to have advised that the draft minutes of the meeting 7th February 1996 6. Not including of 16th February 1996. However, the learned advocate tried to persuade us to show that there was some debate in drafting of the meaning of the resolution, and therefore it was not repeated 16th February 1996. It does not appeal to us. It is as if when such an important decision was taken in the absence of the main promoter of the conference, to oust him from the managing directorship and to install schedules of the next place. It is the grossest act of operation by the board of directors. Sometime after dispatching Dr. Calcutta from the managing directorship, most of the shares were funded by the subsidiary companies of schedule. First to acquire the management and to changes in the management of the company. What can be more unfortunate than this? When a material change is brought about in the management to the detriment of the interest of the main promoter, it is squarely covered under Section 391 of the Act. The company, which is floated by the elder brother and which has been run by the younger brothers in the absence of the elder brother, younger brother and the obstacle and shares are being counted substantially so as to have his operation being squarely covered by Section 7. Apart from this, apart from this, one of the most important features which has been with us is that Dr. Kabul also brought second-hand equipment. Those were cleared by the customs and permission was granted by the RBI. The hospital started with those second-hand and for almost 1 year, no grievance was made and the hospital was running successfully with these equipment. On 22nd March 1997, RBI granted permission for adoption of such and such equity shares of rupees 10 each to applicant number in supply of second-hand. Without permission of the board of directors, filed an application with RBI seeking permission granted for adoption of number 1. RBI on 2nd June 1997 withdrew the permission granted for allotment of the shares. The application. Respondent number 2 presented the director's report in the annual meeting along with audited balance sheet for ended 31st March 1997, wherein capitalization of the second-hand medical supplied by the applicant is reversed. Then the applicants filed application under Section 319 of the Act, CLB directed the respondent company to amend audited balance sheet as of March 1990 and restore capitalization of second-hand supplied by the applicant, which was reversed by the respondent number 2. RBI restored the approval for allotment of the security shares to the applicant 6 March 1999. Of rupees 10 each under Section 91D of the law. On non-repatriation basis against the import of second-hand equipment. This was not enough. This matter was taken up by the respondent by filing a petition such and such challenging the order of the matter kindly found that's of President G. Streams of 3 petitions are thereof. Therefore, this persistent effort was made by the respondents by filing one after another petition for the High Court to somehow reduce the shareholding of the appellate number one. These attempts speak volume of the subtle design on the part of the respondent number to somehow see that the holding of the appellate number one is reduced and the management is passed on to his hands by outstripping appellate officer director by purchasing majority of shareholding. Pursuant to the Calcutta 45. He wanted to control the entire company. Filing of typical petitions in Calcutta High Court at the expenses of the company adversely affected the interests of the company. If this is not operation, Section 397 and under Section 398, then what would be the better case than this? As we fail to understand the view taken by the learned for the person of all given cannot sustain this order. Fear of the imperial that taken by the system. Yes, that this is the case of operation of the member as well as the amount bringing about HTM changes in the management. Since the issue of granting of shares against the medical equipment supplied by the of rupees 3.5 is pending for the Calcutta High Court. This resolution where the CLP has not passed any final order but passed a limited order as mentioned above. However, we have examined the matter in detail and we are satisfied that there is foolproof case of operation. But at the same time, we do not feel inclined to pass an order for winding up of the company because it will not be not in the interest of the parties. Therefore, we allow the appeal set aside the improved order dated 31st March 2005 passed by the Government Secretary of High Court and pass limited direction that all resolutions which have been passed by the Board of Directors or in the annual general meeting or extraordinary general meeting with regard to raising of funds of rupees 40 lakhs and the meeting 16 February 1996, whereby appellant number 1 was stripped of his power resolution by which Dr. Sinha was removed from the office of shares were subsidiary company of Shajul Datta or other persons are banned and will restore the position until 1995 and directed that a fresh meeting be convened and proper decision be taken in the matter in the interest of the company. We confirm the order and direction of CL. Let a board meeting be convened within 21 days notice to all the directors by registered post at their NRI addresses as well as this. The meeting shall be chaired by Komul. Have the right to make nomination. We again make it clear that all the resolutions are secrecy of funds in 1995, removal of Dr. Vinod Prasad Sinha from the Board of Directors, outstripping of Dr. Kamul Kumar Datta from the Managing Directorship, allotment of shares to Shajul Datta's companies and to others, and then next part. And all other resolutions which adversely affect Dr. Kumar Datta and Dr. Vinod Prasad Sinha. These resolutions include the resolution by which the company had allegedly taken a decision to withdraw the application. That resolution is at page 184. Resolution dated 13th April 1996. Page 184. Kindly come to or 184 itself.
Yes.
Number 3, status of medical segment. The later dated such and such from IDPI recording regarding financing of the project in context of the medical equipment already sent by Dr. Kamal Kumar Datta, Chairman Board of Directors, and was placed at the The board discussed at length that kindly turn the page. 185 second paragraph. Further resolve that no application be submitted to Reserve Bank of India, Bombay for allotment of shares to Dr. Kamal Kumar Datta against medical equipment sent to him. This resolution goes by virtue of the Supreme Court order. But it was submitted before the lordships that after the Supreme Court order, nothing remains. That is absolutely correct. Nothing remains of this valid litigations.
This resolution is of 13/4/96.
Once after 36, under the Supreme Court judgment, paragraph 46. Paragraph 46 of the judgment.
Yes, we just read it. Yes.
Last part.
Yes.
From President shall highlight some of the instances to show that how a sample item can address their mallet next part. And both notices have been sent to very short interval. The meeting was convened on 13th April 1996. This is mallet units I showed you. And mallet the order to set aside all this. First, second seal the judge. Sunset Beach 406. Of volume. After these steps were taken by the company on the basis of the Supreme Court order of 2006. Sir, Chaudhary came up with PLB and Mallard had challenged these.
Yes. 17 to 2015 order.
Top ballot, the allegations of Shojol that starts ballot at page 408. Continuation. Kindly come to the third line from the top. Knowing the company was in critical phases, HON'BLE quietly left to USA, refusing to bring any fund into the company. Shojol submits that HON'BLE consciously did not disclose to the board that the equipments were second-hand, not new. The invoices of this equipment do not mention that the equipment is second-hand, though government guidelines mandate disclosure whether the machinery imported is new or used. Shojol at last, on seeing various companies confirm that these equipments are very old models and they were not ready to certify the working condition of the machine. Now, this is the first allegation that kindly come to
We could not locate where you were.
kindly come back to my page 409.
Oh, 9. Sorry. Yes.
409.
Consciously did not disclose.
Line from the top ballot this is the stand taken by Shojol. Now, kindly come to ballot. This is the relevant stand.
Yes.
Kindly come to page 414. Paragraph 1500, HON'BLE's submissions on behalf of HON'BLE starts. The case put out by page 414. Paragraph 15 starts. I come to paragraph 16. On the arrangements entered between them, Dr. HON'BLE brought in medical equipment to the hospital in the year 1995 from USA. Cost estimating to 3 crore 5 lakh 50,000 to 90. Pursuant thereof, the value of the equipment is recorded under the head of capital as fair allocation earning for issuing 30 lakh 55,009 shares at the rate of ₹10 each. Dr. HON'BLE submits that Mr. Shojol admitted in various documents this fact of proposal for allotment of shares against equipment brought in by his brother. There is one document dated 25th August 1993 showing Mr. Shojol writing a letter form of CS at New Delhi for obtaining SIA approval for allotment of shares towards medical equipment proposed to come to the company when HON'BLE dispatched this medical equipment during the year 1994-96. Shojol was in charge of the project implementation, installed this machinery in the hospital, and made it ready for commercial use. HON'BLE says that the financial accounts which were passed by Shojol for the year ending 31st March 95, March 96, and 31st March 97 reveal that the value of the medical equipment was duly capitalized. This fact is also evident in record. That Shojol himself allotted share worth 74 lakhs to Dr. HON'BLE for smart compliance. But when a technical fix was pointed out that RBI permission had to be taken before issuing shares to investment coming from outside, Shojol consciously reversed the entries and transferred the amount to share application account. In the financial account for the years 95-96, it was acknowledged that the share application account represented funds received in kind from Dr. K.K. Dotto, chief promoter, against which equity shares were yet to be issued, pending receipt of approval of RBI under FIRA 1973. Relying on this acknowledgement, Dr. Mahmood says, all that left was candidates to analyze and brought in by Dr. Common. Then, my lord, next part is, my lord, the dispute. Dr. Mahmood says in the year 97, the company started keeping up with having set in the mind of Shajul to grab the entire project for himself to accomplish this every desire. Shajul surreptitiously to keep issue of such and such shares to himself and of himself. My lord, these are the allegations. Kindly come to, my lord, the order starts at the 419 are the issues. Kindly come to the the observation starts. Before going into the merits of submissions made by the council, I place backstory and facts I believe as correct. The kind of that come to page 425. From page 423, paragraph 35. About the lines from the bottom of the line, starting with sometimes it's 420. Paragraph 39 about the line of lines from the
Yes.
Sometimes contracts are implicit and sometimes they are expressed. As we know, the validity of the intention will not change, notwithstanding the mode of contract is express or implicit. All this is evident from the application scheduled in the capacity of director CR for permission to analyze to invest in Indian business. He categorically mentioned in the CR application dated 31st March 1993 that 7 crore is the authorized share capital, out of which paid up capital is 9 crore, out of which 9 crore NRIs would invest rupees 4 crores through cash and rupees 4 crores through medical equipment. And remaining 1 crore would be from Indian shareholders. He also stated that the chief promoter of the business is Dr. Kamal Kumar Dotto, and he said foreign investment of rupees 8 crore will be from Kamal's group. Here, the case, the argument of Shojal is slightly what suppose that 88% to the NRI is only a ceiling limit. It is nowhere said that the foreign investment will be such and such, that is 8 crores. But to be, despite reading that application many times, I could not come to any other inference except an inference to say that the foreign investment would be 8 crores, amounting to amounting to 88.88%. It is not sounding anywhere in the application either the foreign investment would be up to 88.88% or the Indian resident shareholders would have more than 1 crore or more than 11.12% shareholding. Then my lord, kindly come to page 4 to 5. Scheduled made to SIA on 31st May 1993. The hospital did not see the light of the day because the hospital was inaugurated on 15th April 1995 after the arrival of second-hand equipment from US. In support of this application signed by Shajol, Komol also filed a letter of Shajol 2-1 Vijay Kumar Gupta on 25th August 1993, saying that the entire 88.88% of shares should be allotted to Dr. Komol Kumar Datta on repatriation basis. So it could be clear, as early as in 1990, Shajol was privy to the decision for issuance of shares on the basis of such and such capital. Then my lord, can you come to page 425? Up to the top ballot, the second line. Page 425. Had really Shajol been aggrieved of seeing second-hand machinery coming to the company, he should have challenged the same before some court of law, but on the contrary, he gained Komol from having 18.18% share capital in the company as agreed before. He hurriedly allotted shares to himself, making himself majority, and ousted his brother altogether, which the Honorable Supreme Court held as full of operation. Page 425. Top. Stop.
Yes, we have followed.
Then paragraph 40.
45.
40.
40. Yes.
Paragraph 10 of this company petition, Shajol says, Komol did not disclose to the board of the company that the imported equipment is second-hand. The invoices of this equipment do not mention that the equipment is second-hand, as required under the Customs Act. Had there been any objection over the equipment by Customs Authority, the objection should be somewhere in the since Shajol was and looking after the affairs of the company, he should have been aware of the same. Therefore, the main chambers, he has been aware of the fact. Having known this fact, what action he took against against Komol from 1994 until he filed in 1999 before Honorable High Court Calcutta. Had the equipment.
What action he took against? Perhaps it is Sajal. It appears to be S. It should be in the context, it should be.
There is a mistake. Then my next. Had the equipment been objected at customs on the ground equipment is second-hand, what action the customs authorities had taken, upon which Shajol is silent. One thing is fact, customs cleared the equipment and hospital was inaugurated only after most of the equipment was set up in the hospital That time the schedule had no objection to see this hospital run on this equipment. Schedule said he discovered this fact after the IT company on 1996 to the later dated 9th February 1996 written by Kamal saying the equipment is second-hand equipment. Assuming he came to know this only after ITBA is the later company on 9th April 1996. Why Schedule later also kept quiet, except writing a letter to RBI not to give permission to the company to issue shares to Kamal. Had Kamal said anywhere that equipment would be cheaper, this equipment is dysfunctional, obsolete to Schedule only when Kamal initiated action against Schedule, challenging the allotments made to Schedule himself is as bad. The Honorable Supreme Court held all the equipments worth 3.5 crores were supplied by Kamal, which were installed in the same hospitals. Those equipments were second hand, and this is how the hospital started functioning in 1995. It seems that it started running with what we started showing some profitability, and the job started, which led Dr. Doctor and Dr. Sinha to file. Well, this is quoted from Supreme Court then. Therefore, it would not be right on my part to make any additional observation over it when Apex Court already observed the first round of litigation over this aspect, saying what could be more obsessive than preventing Kamal from having shares issued to be supplied by him. Let us see the observations of the Supreme Court, whether the observations are quoted. Yes, paragraph 47 of the Honorable Supreme Court judgment. Kindly document at page 44 to 8. Paragraph 41. Fact of the matter is, each after need to solve Kamal getting shares issued to the medical equipment, and he has remained successful in halting shares going to Kamal to the from 1996. I should not now say separately when the Honorable Supreme Court itself held that hospital was came from Kamal. In fact, the company started making profits with the same equipment that came from Kamal. The capital that has come into the company in the form of equipment subsumed in regulation services and profit to the company. One thing is clear that the value of the equipment could not be converted simultaneously to capital for only one reason, that is for want of RBI approval. That approval in no time came to the company for conversion of 3.5 crores into capital on non-depreciation basis. But by that time, Sadhar already discarded well by ousting Kamal from the company and made allotments to himself, making himself as majority. Not only that, though RBI approved issue of such and such shares to Kamal, consideration to the second-hand equipment supplied to the company on non-depreciable basis. Till date, shares were not issued to Kamal. Since the Honorable Supreme Court held that Schedule acting prejudicial to the interest of Kamal and his acts are oppressive against Kamal, since Kamal is allowed to continue to act as the managing director of the company and pass resolution within 21 days in accordance with law. Kamal, in pursuance of it, passed a resolution on 16 September 2006 allotting shares to him in consideration to the equipment he supplied to the company in the year 1994 and 1995. This is what the truth is. Now the grievance of Schedule. Well, let kindly come to page 432. Paragraph 49. Initially, Shojul himself as director of the company simultaneously captioned the second-hand equipment as capital when it came to equity. I need not reiterate in my order to say that the apex court of us has not been towards it, saying that an attempt was made by the younger brother Shojul to oust the elder brother by denying him his shares for the medical equipment worth 3.5 crores supplied by him from USA. I have already placed apex court's observations over supply of second-hand equipment in the order dated 2006 over the very same issue which Mr. Shojul now complains in his petition on two fronts. One, it is second-hand and obsolete equipment, therefore it should not be converted into capital. Two, it is not by subsection such and such of the company side. On seeing such an observation of the self-same issue from the highest court of this country, can anybody say this second-hand equipment is unfit to become capital? I only can say by reading the judgment of the Honorable Supreme Court that the company had no qualms when paid to the company, with which, when it got a share of hospital, and rather this hospital continued it for some time, it has only become obsolete and overrated when it got into the mind of Shojul to become major in a company set up by his brother Hon'. On this allegation, he landed up in Honorable High Court of Calcutta with a writ petition, etc. Sixth paragraph. The company started with an assumption.
Yes, sorry.
Paragraph. Paragraph. Company started with an assumption that the shareholding of NLI would be 88.18% and the resident Indian shareholding would be 11.12%. Out of 88.88%, 44.44% allotted for medical equipment that comes from NLIs. This arrangement or contract entered amongst the shareholders and directors of the company when it came into existence. It is not something that came into contemplation soon before passing up the resolution. That is on 6th September 2006. In pursuance of the understanding, they had right from the very beginning common supplied rupees 3.5 crores worth of medical equipment to the company, and the hospital started with that equipment and admittedly made profits thereafter. A director would be called interested director when a company wants to enter into a contract with somebody. If that somebody is a director of the company interested in that contract, and abstain himself in taking a decision over a contract or arrangement company proposes to enter into with him or against him. Here the director of the company had this arrangement of allotment of shares against the value of the medical equipment supplied by the company at the inception of the company. Therefore, it would not lie in the mouth of Shojul to say that the board for the first time discussed about allotment of shares in consideration of equipment and passed a trust resolution for allotted shares. It is preferential arrangement. The board agreed at the beginning of the company. The board agreed for supply of medical equipment even before the hospital came into existence. Common supplied medical equipment before inauguration of the hospital. The hospital subsumed the equipment and started showing prosperity, which led to put in the company in the year 1996. Shojul allotted shares to himself and usurped the control of the company. Of course, by the intervention of a company. when the board agreed for allotment of 55,000 shares in consideration to the medical equipment costing rupees 3.5 crores, the company asked for RBI permission for allotting those shares to Common. RBI indeed gave its approval for allotment of those shares to Common. That being the situation, where is the need for the board or the company to relook into the allotment of this 30,25,000 shares to Common? It is not the case of schedule that board has not agreed to allot 18.88% shares to NRI. It is not the case of schedule that board has not agreed to agreed for allotment of shares to the medical equipment. It is not the case of schedule that he has not applied for approval for allotment of 30,55,000 shares to Common in consideration to the equipment. It is also not his case that he was not taking all the decisions taken by the board and the company in sending application to RBI for approval for allotment of these shares to Common in consideration of the medical equipment. As to the allegation that it is second-hand equipment and it was not in his notice until he saw a letter from ITBI, that issue in Paris, still there has been no demands from schedule over company seeking approval for allotment of shares to Common from RBI. The only inference that could be drawn is that the board agreed for allotment of shares to medical equipment. Therefore, now there is no point in arguing that Common is an interested director, etc. And then finally concludes. Finally concludes. Certificate this top one, right? First slide. Those shares were not 438.
Yes.
At the top. Those shares were not issued to Common to the equipment when the company received the equipment. It was used as capital of the company. The machinery took part in doing the business. If money has come into the company as loan or debenture with a clause for conversion into shares, the character of the fund will change from loan to capital or debenture into capital. In this case, the equipment has come into the company for all practical purposes as capital, and it did its job as capital, and it not be shown as capital because the company had to get approval of RBI under FIRA. Except the reason, there was no reason for holding it back from showing it as capital. And if I were to come to
So, Mr. Mitra, you are trying to highlight the various findings, whereas Mr. Mukherjee's submission was that all of it was subject to result of the writ petition.
But these are the findings which this CLB has arrived at. This CLB has arrived at these findings on the basis of the order passed by the Supreme Court, where the Honorable Supreme Court no uncertain terms held that schedule was compulsory, and that is why the entire decisions were set aside and liberty was granted to hold the meeting. The last paragraph. On the basis of that meeting, on the basis of that order, the meeting was held. Today, my lord, what is being sought to be done before your lordship's case, my lord, set aside that. My lord, which in my submission is not permissible. I was showing the CLB orders because, my lord, some portions were shown to show as if, my lord, CLB has, my lord, proceeded on the basis that no, nothing is decided. But kindly look into the observations of the.
Yes, that's why we said you are highlighting that these are actually findings, but this is qualified by what is said at page 449 at the top. where it says that I believe the bench has jurisdiction to decide the issue of allotment subject to outcome of the writ petition. So therefore, you say that these are findings, but the tribunal, the board obviously will say it is subject to result. He says that since it is subject to result, everything is open.
Actual findings are there. Now, whether today there has to be a reason for this honorable court to cover contrary factual continuously. The first CLB, then the Supreme Court, first CLB order
Yes.
under the Commons application,
Yes.
the order is the findings, then the Supreme Court findings from that next application, and thirdly this, all the three courts or the tribunals and the Honorable Supreme Court have continuously held against.
So it is a consistent finding. What you are trying to say is it is consistent.
And whether lordships have seen whether the Supreme Court has also said, and whether that has been reiterated by the CLB, that whether all these three petitions are acts of operation, including this. Three petition part is this.
CLB has said about this writ also.
Yes, Supreme Court also. 3 writs.
So that 3 includes this.
I'll show you. It specifically the Supreme Court speaks about 3 writs. Kindly give me a minute towards the bottom of a page.
Yes, yes.
This one paragraph page 38 speaks of repeated repetitions, but there is another page 38 it states that finding of repeated repetitions in the Calcutta High Court at the expenses of the company adversely affecting the interest of the company. This is not the operation of the Section 97 and the changes under Section 98. Then what would be the better case for? Yes, your stand is
Yes.
Once kindly up to page 38, it was what is the Supreme Court judgment.
Page
38. Line above.
Yes, then true.
The respondents did not feel satisfied and filed the third rate petition on 7th May 2000. This is this rate. Their no stay order was passed. They kindly confirmed hypothesis. Last two lines, the filing of repeated rate petitions in Calcutta and the expenses of company. Tactically, or any other thing.
When do you want?
Or any other thing. Simply Thursday, I may have some difficulty.
Next Tuesday, you mean 19th?
Or yeah.
Tuesday. For further submissions on Yes, there is another case.
Court judgment, serial number 1, Eco Bank.
Actually,
Madam, appear for the respondent.
yes, I wanted to clarify because the list says with CS. So I was wondering what has to be done in the CS. So I'm informed that it is partial of the expression in connection with. So nothing has to be done in respect of the CS. Only the appeal order has to be passed in the appeal, and the GS will accordingly be disposed of.
I'm grateful.
Yes, the appeal is dismissed.
I'm deeply obliged, madam. I'm deeply obliged. I'm grateful, madam.